Cool. Hi.
Hi,
Hello.
we're back.
We are back. And with me today, my dear colleague Thea, IP and privacy expert here at Spirit Legal. Hi, Thea.
Hi, Peter. And Peter, on the other hand, partner and head of data protection and privacy, also at Spirit Legal.
Very cool. So today's episode, it's episode basically number 3 since we started counting in a kind of weird way with 00, but now it's basically episode 3. Will revolve around copyright, artists, and AI training. It will be focusing on this very, very contentious topic. This is us. You've seen us before. Something for where we would say thank you is that we have enough followers on LinkedIn now to start to stream the LinkedIn live events directly on RegInt, and we don't have to use up our law firm's account anymore. Everything in one place is on Linktree/RegInt. There you can find previous episodes and the various channels. For some unfortunate reason, YouTube is the only open access source for our show and for the recordings, but we stream directly to various Twitter accounts and the LinkedIn page that you may have seen before. So also let us introduce the next episode. Tia.
Coming up August 9th. So in approximately 3 weeks, and by scanning the QR code right now, you can already sign up for it so that you don't miss it. We'll be talking about privacy, machine learning, data, and everything revolving around machine learning on vast amounts of data that is protected. Probably.
Yeah, definitely a huge topic, an immensely important topic, but I mean, all topics currently are super important. Anyway, let's have a look at what is going on in this world or outside of our offices. Tia, you can start to rant.
Yeah, and it's a wild world, actually. And today we're going to start on a slightly different note. So I'm gonna start with this. And well, we probably don't need to educate anyone on the fact that France is going through a rough period right now with the whole Nahel Merzouk protest. And now you might be wondering why I'm mentioning this. Am I really trying to start my own news channel right over here? Actually, I'm not. The reason I'm mentioning it is because this isn't really helping. And now I'm not going to rant about Chaos GPT in particular, although I had to put it in here because I just think that the name is amazing. Chaos GPT, an AI tool that seeks to destroy humanity. Wonderful. I'm actually going to rant about some other very particular AI bots that are not helping the situations that are escalating quickly enough with just us humans instigating them, such as the protests going on in France. And namely, these bad boys are, for instance, Quran chatbot. And now I don't know if you can see it on the slide, but actually the person asked Quran to explain how we should treat polytheists. And to ask Quran chatbot told her to kill them if they don't repent, of course. By the way, the thing that you see on the right part of the screen is the answer that I got, and apparently they fixed the bug. And yes, I can agree, something went terribly wrong over there. However, yeah. And that's, of course, not the only one we have. We also have Bible GPT. My conversation with Bible GPT was not that exciting, fortunately, but maybe I just asked the wrong questions. And then we also have Cheetah AI in India saying it's fine to sacrifice life to save Dharma. Again, a wonderful bug that was then later fixed. So this is the answer that I got. Apparently it's not fine to sacrifice life to save Dharma after all. But again, the bug was fixed only after the thing went public. And actually, it's not just the machine learning models that are advising us in religion. It's also Pope advising us on machine learning models. And together with Santa Clara University, Markkula Center for Applied Ethics, Vatican actually formed a new organization called the Institute for Technology, Ethics and Culture. And the first project of this institute is a handbook titled Ethics in the Age of Disruptive Technologies and Operational Roadmap. That's quite an ambitious title. It's meant to guide the tech industry through the murky waters of ethics in AI, machine learning, encryption, tracking, and more. And it basically has 140 pages elaborating a lot of the things that we already know, but with a slight twist. For instance, the anchor principle for companies is ensuring that our actions are for the common good of humanity and the environment. That's very specific and very implementable, great for an operational roadmap. But anyways, that's what we have. And you do have to subscribe to Marcula's newsletter in order to be able to access the handbook. But still amazing, God bless us all. And despite all this, the frenzy is amping up the volume. So we have 45% of executives saying that ChatGPT has prompted an increase in AI investment. And the frenzy looks something like this. So we have Apple. We mentioned the new VR glasses in the first episode, and that actually made them break the $3 trillion net worth. NVIDIA, quoting their own statement, powering the world's fastest GPUs and offering the ultimate platform for gamers and creators, also broke some records. And we have Microsoft leading the merry bunch with, well, predicted stock records of 10 billion in annual AI revenue. So that's only AI revenue. Anyways, the frenzy is heating up, and then we say that the models are slow learners. Well, I might beg to differ. And by the way, just shortly after letting their code assistant run wild and free, we have China joining the chatbot party. With a model that allegedly outperforms ChatGPT and even GPT-4, especially in, and if I can have a drum roll now, Chinese. Well, that's slightly anticlimactic, but apparently it's also good in English, at least better than ChatGPT, as well as being able to nail multiple choice questions. And all this aside, you do need to stay on track and up to date with the newest tech and so. And so we have the very first prompting course. Don't miss up on enrolling into this 10-minute course. Not terribly exciting if you have experience. When it comes to prompting, it's mostly learning the basics, and then, well, it's basically learning by doing. However, for those with no experience, this might be a solid place to start. But now finally, to lead us into today's topic, there are a couple of recent events that caught our attention. Two of them being, first, an artificially produced book that kind of makes it highly unattractive to actually specialize on a niche topic when a bot can summarize it much faster and at a much lower price than your 5-year education, time, energy, and ideas. Well, you might reconsider if you want to actually invest all that. And we also have models artificially reproducing people's voices. In this article, an actor's voice was resold without his knowledge because he apparently gave up full rights over a recording of his voice. Never mind that happened years ago in ancient history when we didn't have technologies that could reproduce them, nor an idea that something like that could come as fast as it did. We are talking about Greg Marston, a British voice actor with more than 20 years of experience. And he recently stumbled across his own voice being used for a demo online by an app called Revoicer, which is an AI tool that converts text into speech in 40 different languages. So imagine hearing yourself speak Chinese, even though you never agreed to it. And now these are some of the technologies that are doing things like that. So I already talked briefly about Revoicer. We also have DID, which posted an ad on Mandy.com offering 500 euros for a half-day gig of recording scripts based on which they were developing artificial presenters. Well, that sounds fair. getting $500 to be replaced permanently. On the other hand, I do tend to believe that you are still not going to be able to mimic or artificially create an overall good presentation. There's a lot of science in there, but maybe I'm just overly optimistic. And of course, I did have to try a preview of this presenters or whatever you want to call them. And you do have to sign out to find all that she has to say about it, wink. But I did sign up, I did try it, wasn't terribly impressed. And yeah, also, I don't know how I feel about the whole my mystical guide is a darker skinned woman, because who else would be my mystical guide? Yeah, anyways, not terribly impressed with these digital presenters, but who knows, hey, maybe they develop as well. And just to finish off with the most disturbing of them all, this hit Twitter 3 days ago. So we have an arguably copyright infringement, because Heidi is kind of already a thing, you know, that will also give you nightmares just because, yeah, why not? And as you see the trailer and maybe soon the movie, who knows, the trailer does escalate very quickly, and I can definitely recommend it as a must-see byproduct of the world we happen to live in. Welcome. We have copyright infringing trailers, cookies, and lawsuits for all those who can't stand it. And we had a bunch of them actually in the US recently. So these are the 3 very recent ones, 2 from the 7th of July, 1 from the 28th of June, all filed by the Joseph Saveri law firm, and all following a very similar line of reasoning that we will introduce later. But there is one more that I wanted to mention just because it also dropped on the 28th of June, and I personally believe that it's a copyright treasure. Maybe the models can learn something from it. In any case, the lawsuit tells a story of user expectations and violating those expectations, of infringing upon the rights of privacy, of the necessity to protect our children, of the story of trust and the betrayal of distrust, of the complete lack of transparency. The lawyers show profound knowledge of the topic and give a better overview than most of the papers that I read so far. So I can definitely recommend it. And brace yourself, they introduce 14 charges based on various laws in the US, everything from illicit data collection, using data protected by confidentiality of communications, unlawful business practices, BIPA violations, negligence, invasion of privacy, intrusion upon seclusion, larceny, conversion, unjust enrichment, failure to warn, and more. It's a hefty piece of work with 140 pages, if I'm not mistaken, and I would say it's definitely worth your time, but we are probably going to talk more about that in our next episode on privacy. Today, however, we are going to focus on copyright, but not before we give you some more of the latest news with a bit of a deeper dive in them.
Yeah, that's right. So AI news. Thank you, Tia, for introducing us to the most fancy news of the last weeks. But there are more mundane topics that we should talk about, and for us, it's usually it takes a huge effort to sift through the news and to find out which news or which papers are relevant to the audience and also to us as lawyers and to the privacy and tech community. So let's begin with something here, the man behind the AI Act. Tia, do you want to tell us about it?
Yeah, I definitely want to recommend this great podcast by Luca Bertuzzi, published on Euroactive on the 30th of June. The conversation is with Andrea Renda. He's a senior fellow at the think tank called CEPS that played a crucial role in actually shaping the AI Act behind the scenes. And Andrea gives a very pragmatic and objective opinion on the shaping of the Act and its current design. He explains the risk and application-based approach together with the logic behind them, but together also with key problems, such as failure to account for models that can have multiple uses, read foundation models. He prognoses future trends such as platformization of the AI market, concentrating around foundation models, with a strong focus apparently on probabilistic and Bayesian technologies. For all those non-tech people, that is basically a critique of the act, because the AI definition currently includes machine learning models, whereas previously it explicitly included Bayesian training models. So a bit of both. He also briefly introduces the newest document on the EU AI agenda, AI Code of Conduct, drafted in the context of EU-US Trade and Technology Council, as well as compares it with the much more transparent approach taken by NIST, that is establishing a new public working group on the topic of generative AI, much more transparent and including private and public stakeholders. Definitely worth your time and will get you up to speed on a lot of things.
Yes, next topic, not so pleasant.
Next one is not as optimistic, I would say. So this one was posted by BBC on the 28th of June. BBC reports on an open source version of Stable Diffusion, which can be released off all its built-in constraints and used, for instance, to create child pornography. Now, this is next level, if you ask me. I'm also not sure if it makes me feel better or worse. Probably worse, since the system still had to be trained or fed similar pictures at some point to be able to recreate them later. And by inserting the right prompt, you can actually re-victimize the victim a virtually unlimited amount of times. The whole scandal was discovered on Patreon, where the images were spread, of course, against their policies and blocked after a user would complain, which is, of course, a rather unfortunate mode of dealing with the situation, because ideally you wouldn't want those pictures published after all, at all. However, yeah, now we have the scandal. At least we know that it's happening.
Yes, and for something completely different, CJEU decision. What happened there?
And for something completely different, we're going to give you the latest updates from the metaverse, because there's been a lot of them. And I'm not meaning the actual metaverse, I'm meaning like the universe around meta platforms. We are going to start off with the newest decision by the CJEU, 4th of July. Meta can no longer rely on legitimate interests, either for processing the user's data or for setting cookies or for anything else. However, legitimate consent apparently still remains a possible option. How exactly it could be implemented, the court, of course, does not say, but it doesn't exclude it entirely. Apart from that, we also had Meta launching a Twitter knockoff, which until now was only launched in the US and the UK with 30 million users on the first day. It was launched as an Instagram incorporated app because it's well integrated kind of also with Instagram. And it's apparently supposed to be for creators that want an alternative to Twitter that is sanely run. That was actually posted by Mario Nafal, Meta executive. Now, how sanely they run Facebook and Instagram, I'm not sure, but maybe they will run Threads more sanely. In any event, Musk is not happy about it, and he wants to sue them for allegedly violating trade secrets and copying Twitter. Competition is fine, cheating is not. Well, I can agree with that. I don't know if they actually copied it. I can tell from the screenshot it kind of looks similar, but still. And Musk is not the only prominent person that had something to say about it. We also had Jake Dorsey, who is still processing stuff, including what Threads collects on its users. Well, and if you scroll a bit down, you have the category other data. That's really fun because all the things that they mentioned apparently wasn't broad enough. So they had to, keep that option open as well. In any event, exciting times we live in.
Definitely, the metaverse is gonna keep us as lawyers awake for a long time. Since the collective redress is entering the stage later this year in Europe, we're gonna see how this turns out. But there are other developments in this world And there was a very fine paper that I came across, and it's called Assessing Cross-Cultural Alignment Between ChatGPT and Human Societies, an Empirical Study. Why would a lawyer care about that? Yeah, well, basically, one, it's in the AI Act that data has to be geographically appropriate. But in this paper, which is interesting, the researchers, they embark on an investigation into the cultural background of the data behind GPT by analyzing its responses to questions specifically designed to measure human cultural differences. And what did they discover? Well, the findings suggest that when prompted with an American context, surprisingly, ChatGPT demonstrates a strong alignment with American culture. However, it appears to be less effective in adapting to other cultural contexts. The findings on this study shed light on the importance of considering cultural factors in the development and utilization of language models such as GPT or others, of course. And the explorations of the researchers didn't stop in America. By employing different prompts to probe the model, they unveiled an intriguing revelation. They find that when presented with English prompts, the variance in GPT responses decreases, leading to a flattening out of cultural differences and in turn bias towards mainstream culture in general. So that's definitely interesting, but maybe we are worrying too much because ChatGPT's novelty is wearing off. Traffic on ChatGPT drops nearly 10% in June, says a recent study about web traffic. The situation is not so well for OpenAI and users facing chat LLMs in general. We saw other players entering the stage. The disadvantages of hallucinations and excessive fine-tuning to steer clear of sensitive subjects seems to outweigh the advantages of significant time savings. Maybe that's good news, possibly. Other papers, very interesting for anyone using large language models. You can see, and maybe you should focus on this chart here, retrieval of documents, first position, fifth, 10th, 15th, 20th position of a document with the answer. The problem is, and the paper is called Lost in the Middle, How Language Models Use Long Context. This study reveals some findings that the performance of a large language model in relation to the location of relevant information within the input context plays a certain role. The research indicates that these models achieve its highest performance when the information is located at the beginning or at the end, as you can see in the chart. That's why this picture is so telling. So at the beginning or at the end. However, the model's performance significantly degrades when it needs to access relevant information in the middle of the input. I mean, you could have figured that out by using extensively ChatGPT or GPT in general. But furthermore, at the context or the input context grows longer, the model's performance experiences a substantial decrease in general. So these results highlight the importance of information placement within the input context. Then there's another study, super important also, that focuses on the distractibility and how irrelevant context affects the accuracy of LLMs. So the researchers, they introduced a benchmark data set called Grade School Math with Irrelevant Context, and that includes irrelevant information in arithmetic reasoning problems. They find that including irrelevant information dramatically decreases model performance. Mitigation strategies, so like self-consistency decoding and instructing the model to ignore irrelevant information, are proposed to address this issue. But all of that might lead to the drop in traffic on GPT or ChatGPT, because we see it might be useless, or LLMs might be almost useless if you have longer prompts. Interesting developments. There's another very, very certainly interesting paper. It's called Frontier AI Regulation, Managing Emerging Risks to Public Safety. So in the last episode, we mentioned that there is a lot of fear-mongering and scaring people because of the alleged risks of general artificial intelligence, which might still be a very remote risk. But this paper about like frontier AI models is rather interesting. The paper highlights challenges in regulating these models, such as unexpected dangerous capabilities and difficulties in preventing misuse and proliferation. We talked about that last time with a model that was able to, like, unconstrained, able to create a dialogue for hacking a bank and laundering money, and other features too. So to address these challenges of unexpected, dangerous capabilities, the authors, they are all like from the US, basically. They propose 3 building blocks for regulation: standard setting processes, registration, reporting requirements, and compliance mechanisms. So interesting. The paper suggests options like also granting enforcement powers to authorities. It also proposes initial safety standards, including risk assessments, external scrutiny, informed deployment decisions, and post-deployment monitoring. TIA sounds much like the EU AI Act, and that's surprising given the origin of the authors. That's why I wanted to talk about the paper. But back to the tech stuff, we see the introduction of, or at least the possibility of, LongNet, scaling transformers to 1 billion tokens, which is a lot. Size matters in the realm of large language models. Scaling sequence length has become a critical demand. I want the model to read a book. I want the model to read all the documents in a data room, and I want to perform queries on that data. So however, existing methods have struggled with either computational complexity, which means like your computer is just going to die, or the API is not going to work for that, or model expressivity, limiting the maximum sequence lengths. But fear not, because a team of researchers has developed this solution called LongNet, and it's a variant of the transformer model, and it can scale sequence lengths to over 1 billion tokens without sacrificing performance on shorter sequences. That is interesting. Not sure how that relates to the other papers about like the distractibility and the performance loss in the middle of a sentence or in the middle of the input sequences, but the experimental results demonstrate, according to the authors always, that LongNet performs exceptionally well in both long sequence modeling and general language tasks. Interesting. Further into the rabbit hole of legal and technical developments, there is a new paper, and it's called Right to be Forgotten in the Era of Large Language Models, Implications, Challenges, and Solutions. And it's an interesting paper. It's a nice paper because it also has examples, even though sometimes from a legal perspective, it's a bit weird because it still mentions the directive, the good old directive that was replaced by GDPR. But still, the Right to be Forgotten was developed a long time ago, and that allows individuals to request the deletion of their personal data by organizations, by the controller. While search engines have mechanisms to comply with the RTBF requests, the emergence of large language models and their chatbot, they pose a new challenge. Last week, or last time, we had this example of Christian Benefeld. He requested the deletion of his name from OpenAI, and they complied with the request. Rightfully so, and his name was later redacted in any output of the model. So in this paper, these researchers, they propose solutions like machine unlearning, even though I think unlearning is impossible, but model editing, prompt engineering, and so that's a really important and interesting topic. And also, Google thinks the same. They are announcing their first machine unlearning challenge that was announced late June. The machine unlearning challenge is a competition, and participants will tackle a realistic scenario where a certain subset of training images must be forgotten to protect privacy or individual rights. The competition will be hosted on Kaggle. It's a renowned platform for data science. Competitions and submissions will be evaluated based both on the quality of the forgetting, that's interesting, that's an interesting term, and model utility. quality of forgetting. I usually, when I forget, it's just gone. But machines, maybe they can't forget or unlearn. But machine learning, or machine unlearning in this case, goes beyond privacy protection. It can also be employed to eliminate inaccurate or outdated information from trained models, rectify harmful or manipulated data, and address outlier data. So that's an interesting event, and the outcomes are definitely worth watching. And that's not yet the end of it, because Google is being sued for allegedly scraping data from users without consent and violating copyright laws to develop its AI products. This very recent lawsuit claims Google has been secretly stealing everything ever created and shared on the internet and using it to train its AI, including chatbot Bard. Bard finally available in Europe. Google's general counsel called the claims baseless and stated they use data from public sources responsibly. Do you remember the 252 of 21 decision by the CJEU about like publicly available data? So at least in Europe, that's not going to fly. So the lawsuit seeks a temporary freeze on Google's AI tools and compensation for those whose data was allegedly misappropriated. The lawyers argue that personal data is valuable and nobody has the right to just take it. Complaint points to a recent update to Google's privacy policy. You might have seen that one too. Google's privacy policy that explicitly states the company may use publicly accessible information to train its AI models and tools such as Bard. The interesting thing is that Google themselves, they say, we've always done that, and it's always been there. Tia, you check their privacy policy. Has it always been there?
It's actually an interesting thing. So when you look at their updated policy right now, it's kind of still not there. So I'm not sure what's going on there. However, if you look at changes made and amendments made, then you see the addition. So in any event, it was definitely not always there. And whether it's there now, well, kind of, if you go to compare two versions.
And that's super interesting. And the lawyers the lawyers are on our side here. The lawyers from Clarkson, at least. Google needs to understand that publicly available has never meant free to use for any purpose, says Tim Giordano from Clarkson. And artificial intelligence can't work with our data, obviously. So Politico had a big idea, and they proposed we should all be paid for it. And I think that's beautiful. Also,
well, that's the very least they could do.
That's the very least they could do. Right. I'm going to remove that one from the stream. So we are now going to focus on our today's topic,
the most diving into copyright.
Diving into copyright. So
and we are going to we are going to do that with actually the Senate hearing that took place approximately 12 hours ago in the US. So today we are going to focus on the US, on the fair use doctrine, and we are actually going to listen to 3 of the 5 people who spoke at the Senate hearing and see what they had to say about the whole problem.
Right. The Senate hearing took place yesterday, late in the evening for Europeans, at 3 p.m. for Americans. And there were present Matthew Zack, professor of law, artificial intelligence, Dana Rao. He's the first one here that we are going to feature. He's executive vice president, general counsel, and chief trust officer, whatever that means, for Adobe Inc. And concept artist, illustrator, and fine artist Carla Ortiz. So let's first have a look at what Mr. Rao has to say, and I hope it's
Chair Coons, Ranking Member Tillis,
working. It's working.
Thank
Cool.
you for the opportunity to testify here today. My name is Dana Rao, and I'm General Counsel and, as Senator Coons noted, Chief Trust Officer at Adobe. I'm happy to provide you with the secret certificate you need to get that title if you'd like after the hearing. Since our founding in 1982, Adobe has pioneered transformative technologies in all types of digital creation, from digital documents like PDF to image editing with Photoshop. Our products allow our customers, who range from aspiring artists to wartime photojournalists to advertisers and more, to unleash their creativity, perfect their craft, and power their businesses in a digital world. AI is the latest disruptive technology we've been incorporating into our tools to help creators realize their potential. You've all seen the magic of text-to-image generative AI. Type in the prompt, cat driving a 1950 sports car through the desert, and in seconds, you'll see multiple variations of a cat on a retro road trip appear before your eyes. We've launched generative AI in our own tools, Adobe Firefly, and it's proved to be wildly popular with our creative professionals and consumers alike. In my written testimony, I explore a comprehensive framework for responsible AI development that includes addressing misinformation, harmful bias, creator rights, and intellectual property. Today, given Adobe's focus on our millions of creative customers and our leadership in AI, I'll focus on how the United States can continue to lead the world in AI development by both supporting the access to data that AI requires and strengthening creator rights. The question of data access is critical for the development of AI because AI is only as powerful and as good as the data on which it is trained. Like the human brain, AI learns from the information you give it. In the AI's case, the data it's trained on. Training on a larger data set can help ensure your results are more accurate because the AI has more facts to learn from. A larger data set will also help the AI avoid perpetuating harmful biases in its results by giving it a wider breadth of experiences from which it can build its understanding of the world. More data means better answers and fewer biases. Given those technical realities, the United States and governments should support access to data to ensure that AI innovation can flourish accurately and responsibly. However, one of the most important implications of AI's need for data is the impact on copyright and creators' rights. There are many outstanding questions in this space, including whether creating an AI model, which is a software program, from a set of images is a permitted fair use, and whether that analysis changes if the output of that AI model creates an image that is substantially similar to an image on which it is trained. These questions will certainly be addressed by courts and perhaps Congress, and we are prepared to help assist in those discussions. Adobe recognized the potential impact of AI on creators and society, and we've taken several steps. First, we trained our own generative AI tool, Adobe Firefly, only on licensed images from our Adobe Stock collection, which is our stock photography collection, openly licensed content, and works that are in the public domain where the copyright is expired. This approach supports creators and customers by training on a data set that is designed to be commercially safe. In addition, we're advocating for other steps we can all take to strengthen creator rights. First, we believe creators should be able to attach a do not train tag to their work. With industry and government support, we can ensure AI data crawlers will read and respect this tag, giving creators the option to keep their data out of AI training data sets. Second, creators using AI tools want to ensure they can obtain copyright protection over their work in this new era of AI-assisted digital creation. An AI output alone may not receive copyright protection, but we believe the combination of human expression and AI expression will and should. Content editing tools should enable creators to obtain a copyright by allowing them to distinguish the AI work from the human work. In my written testimony, I discuss our open standards-based technology, content credentials, which can help enable both of these creator protections. Finally, even though Adobe has trained its AI on permitted work, we understand the concern that an artist can be economically dispossessed by an AI trained on their work that generates art in their style, in the Frank Sinatra example you gave. We believe artists should be protected against this type of economic harm, and we propose Congress establish a new federal anti-impersonation right that would give artists a right to enforce against someone intentionally attempting to impersonate their style or likeness. Holding people accountable who misuse AI tools is a solution we believe goes to the heart of some of the issues our customers have. And this new right would help address that concern. The United States has led the world through technological transformations in the past, and we've all learned it is important to be proactively responsible about the impact of these technologies. Pairing innovation with responsible innovation will ensure that AI ultimately becomes a transformative and true benefit to our society. Thank you, Chair Coons, Ranking Member Tillis, and members of the committee.
Thank you, Mr.
Interesting. Tia, what do you think about his testimony?
A lot of surprises there. Models need a lot of data to be good. Weird.
Yeah.
But what I find interesting, or the most interesting part of his statement, is first, Adobe is, of course, the good guy here. They only trained on licensed stock data, meaning their own data. So, well, not everyone is so big to have their own data collection, but okay, yeah, Adobe, great for them. But what I find the most interesting is the last part where he wants to hold accountable people who violate copyright, meaning an average Joe that uses the program to create something that they really shouldn't. Well, yeah, I guess that kind of resolves them of any responsibility, and it's working out pretty well for them.
That sounds nice. 2 comments on that. Like Adobe trained without explicit permission, trained their Firefly on their licensed stock photographs, but whether that's like a permitted use is still it's debatable. And also when he mentions a certain style of creating pictures mainly or videos, for someone offering like not so stylish stock photos, stock pictures, stock videos, that's of course an easy thing to say because he doesn't have those. And but interesting, yes, I understand that there is some value to his statements at the end, of course. Let's continue with
Professor.
Jay Coons, Ranking Member Tillis, members of the subcommittee. Thank you for the opportunity to testify here today. I'm a professor of law in AI, machine learning, and data science at Emory University, where I was hired as part of Emory's AI Humanity initiative. Although we're still a long way from the science fiction version of artificial general intelligence that thinks, feels, and refuses to open the pod bay doors, recent advances in machine learning and artificial intelligence have captured the public's attention and apparently lawmakers' interest. We now have large language models, or LLMs, that can pass the bar exam, carry on a conversation, create new music and new visual art. Nonetheless, copyright law does not and should not recognize computer systems as authors. Even where an AI produces images, text, or music that is indistinguishable from human-authored works, it makes no sense to think of a machine learning program as the author. The Copyright Act rightly reserves copyright for original works of authorship. As the Supreme Court explained long ago in the 1884 case of Burrow-Giles lithographic, authorship entails original intellectual conception. An AI can't produce a work that reflects its own original intellectual conception because it has none. Thus, when AI models produce content with little or no human oversight, there is no copyright in those outputs. However, humans using AI as tools of expression may claim authorship if the final form of the work reflects their original intellectual conception in sufficient detail. And I've elaborated in my written submissions how this will depend on the circumstances. Training generative AI on copyrighted works is usually fair use because it falls into the category of non-expressive use. Courts addressing technologies such as reverse engineering, search engines, and plagiarism detection software have held that these non-expressive uses are fair use. These cases reflect copyright's fundamental distinction between protectable original expression and unprotectable facts, ideas, and abstractions. Whether training an LLM is a non-expressive use depends ultimately on the outputs of the model. If an LLM is trained properly and operated with appropriate safeguards, its outputs will not resemble its inputs in a way that would trigger copyright liability. Training such an LLM on copyrighted works would thus be justified under current fair use principles. It's important to understand that generative AI are not designed to copy original expression. One of the most common misconceptions about generative AI is the notion that the training data is somehow copied into the model. Machine learning models are influenced by the data. They would be pretty useless without it, but they typically don't copy the data in any literal sense. So rather than thinking of an LLM as copying the training data like a scribe in a monastery, it makes more sense to think of it as learning from the training data like a student. If an LLM like GPT-3 is working as intended, it doesn't copy the training data at all. The only copying that takes place is when the training corpus is assembled and pre-processed, and that is what you need a fair use justification for. Whether a generative AI produces truly new content or simply conjures up an infringing cut and paste of works in the training data depends on how it is trained. Accordingly, companies should adopt best practices to reduce the risk of copyright infringement and other related harms, and I've elaborated on some of these best practices in my written submission. Failure to adopt best practices may potentially undermine claims of fair use. Generative AI does not, in my opinion, require a major overhaul of the US copyright system at this time. If Congress is considering new legislation in relation to AI and copyright, that legislation should be targeted at clarifying the application of existing fair use jurisprudence, not overhauling it. Israel, Singapore, and South Korea have recently incorporated fair use into their copyright statutes because these countries recognize that the flexibility of the fair use doctrine gives US companies and US researchers a significant competitive advantage. Several other jurisdictions, most notably Japan, the United Kingdom, and the European Union, have specifically adopted exemptions for text data mining that allow use of copyrighted works as training for machine learning and other purposes. Copyright law should encourage the developers of generative AI to act responsibly. However, if our laws become overly restrictive, then corporations and researchers will simply move key aspects of technology development overseas to our competitors. Thank you very much.
Thank you, Professor.
Very interesting. Tia, your take on this?
Very interesting. I'm actually thinking how I love the guy falling asleep next to the Professor Sag on the right side. Yeah, does say something. In any event, his fair use as it falls in the category of non-expressive use argument, I think kind of falls in the water as soon as he starts thinking that the models can actually, like at least the humans who operate the models can actually use it for expressive uses. So that just makes the whole thing fall apart, because if they can use it for expressive uses, then what the models are doing is in some way or another an expressive use. And the second really annoying part of his talk was that the models don't copy data in a literal sense. They only learn as a student. Yes, maybe they don't copy in a literal sense. However, if you translate words into numbers, vectors, binary system, whichever programming language you can think of, it's still kind of the same data unit. It's just in a different language format, whatever you want to call it. So again, basing your whole argument on they're not literally copying anything is a very shaky ground. And of course, the most important thing at all is not to lose all the tech companies to the competition, to the other countries that have all the exceptions.
And an obvious argument being made in like every country on Earth at the moment. The thing that's like was interesting for me was the contradiction. And when he said no storage in any literal sense, but acknowledges that those models may exactly reproduce their training data if trained irresponsibly. So what is it? Is it a mathematical or a computer science problem? So they don't store at all? Or do you have to apply certain practices so that it's not too obvious that they store the data? Interesting. We're gonna have a deeper dive into that later on. Now let's focus on the next testimony, last testimony for us.
Yes. Chairman Coons, Ranking Member Tillis, and esteemed members of the committee, it is an honor to testify before you today about AI and copyright. My name is Carla Ortiz. I am a concept artist, illustrator, and fine artist. And you may not know my name, but you know my work. My paintings have shaped the worlds of blockbuster Marvel films and TV shows, including Guardians of the Galaxy 3, Black Panther, Loki, you know. But specifically, the one I'm most happiest of is that my work helped shape the look of Doctor Strange in the first Doctor Strange movie. I have to brag about that a little bit, sir. I love what I do. I love my craft. Artists train their entire lives to be able to bring the imaginary to life. All of us who engage in this craft love every little bit of it. Through hard work, support of loved ones, and dedication, I have been able to make a good living from my craft via the entertainment industry, an industry that thrives when artists' rights to consent, credit, and compensation are respected. I have never worried about my future as an artist, until now. Generative AI is unlike any other technology that has come before. It is a technology that uniquely consumes and exploits the hard work, creativity, and innovation of others. No other tool is like this. When first researching AI horrified me, I found that almost the entirety of my work, the work of almost every artist I know, and the work of hundreds of thousands of artists had been taken without our consent, credit, or compensation. These works were stolen and used to train for-profit technologies with data sets that contain billions of image and text data pairs. Through my research, I learned many AI companies gather copyrighted training data by relying on a practice called data laundering. This is where a company outsources data collection to a third party under the pretext of research to then immediately use commercially. I found these companies use vague terms like publicly available data or openly licensed content to disguise their extensive reliance on copyrighted works. No matter what they're saying, these models are illegally trained on copyrighted works. To add even more insult to injury, I found that these for-profit companies were not only permitting users to use our full names to generate imagery, but encouraging it. For example, Polish artist Greg Rutkowski had his name used as a prompt in AI products over 400,000 times. And thus are the lower ends of the estimate. My own name, Carlo Ortiz, has also been used by these companies thousands of times. Never once did I give consent. Never once have I gotten credit. Never once have I gotten compensation. It should come as no surprise that major productions are replacing artists with generative AI. Goldman Sachs estimates that a generative AI will diminish or outright destroy approximately 300 million full-time jobs worldwide. As Ranking Member Tillis mentioned earlier, copyright-reliant industries alone contribute $1.8 trillion of value to the US GDP, accounting for 7.76% of the entire US economy. This is an industry that employs 9.6 million American workers alone. The game plan is simple: to go as fast as possible, to create mesmerizing tales of progress, and to normalize the exploitation of artists as quickly as possible. They hope when we catch our breath, it'll be too late to right the wrongs, and exploiting Americans will become an accepted way of doing things. But that game can't succeed, as we are here now, giving this the urgency it so desperately deserves. Congress should act to ensure what we call the 3 C's and a T: consent, credit, compensation, and transparency. The work of artists like myself were taken without our consent, credit, nor compensation, and then used to compete with us directly in our own markets. An outrageous act that under any other context would immediately be seen as unfair, immoral, and illegal. Senators, there is a fundamental fairness issue here. I'm asking Congress to address this by enacting laws that require these companies to obtain consent, give credit, pay compensation, and be transparent. Thank you.
Thank you, Ms. Ortiz.
Very interesting.
Very, very interesting, very emotional speech that she had there. Basically, my only comment is that if she's worried for her career, and she has been working closely with tech productions for movies and so on and so forth, then I think the other guys have even more reasons to worry.
Everyone in this field, everyone working, creating things, should be worried. Yes, excellent speech from Carla Ortiz. Of course, Carla would have been on the show live, but unfortunately she had to travel back from DC, so we were showing her live statement from yesterday evening. We also have another expert on copyright law, and I'm gonna introduce him in a second. Wait a second, and this is gonna work, I think. So it's Adam Volek. He is a partner at Fox Rothschild in the US in Palm Beach, Florida. And Adam was so nice to send us a recorded message about with his statements about generative AI and copyright issues, and he's gonna add even more ideas to the whole discussion before we dive into the technical details later. So I'm gonna play his recording right now. Second.
Hi, my name is Adam Wolek, and I'm an intellectual property partner with Fox Rothschild in the United States. I'm here to talk about copyright law and its implications and overlap to artificial intelligence. For instance, recently we've seen new suits claiming copyright infringement over AI companies such as OpenAI and Meta and so forth. Recently, in July, famous comedian and author Sarah Silverman and other authors sued OpenAI and Meta and their affiliates for copyright infringement, amongst other things. What they claim is that OpenAI was effectively trained on their books and material. Their claim for copyright infringement is based upon OpenAI's use of their material to effectively read and copy the works, and in order to train the programs in order to have that same type of writing style and potentially humor. By copying those works to train them, that implicates the direct copying clause of the Copyright Act. And they also claim that their output of the AI, even though it may be different than their works, would be a derivative of their work, meaning a change or a building upon their work. So even though it may not be the same, that because it originated from their work, they claim that it's a derivative work. Interestingly, they also raised other types of infractions, including a DMCA claim for misuse of their copyright management information. Now, you may know this as the information that comes sometimes before the book. An art is sometimes considered the signature of an artist on their piece and so forth. They're saying that by copying that book, they must have removed the copyright management information, which is a separate cause of action under U.S. law and a separate basis to sue. That could also include statutory damages and attorney's fees, separate and apart from copyright infringement. Now, Ms. Silverman and the other plaintiffs also raised other allegations, including unjust enrichment, that these companies were basically received a benefit without paying them. The other claims that they have made were under state law. Now, this is going to largely depend upon which state these lawsuits were filed. In this case, this was filed in federal court in the Northern District of California, San Francisco Division. This is based upon the locations of OpenAI and Meta and so forth, including the presumption that they have their office there. With that, the plaintiffs also sued not just these companies, but also the investment vehicles behind these companies and their affiliates. So, because the suit is still really new, we don't know how that will play out, but it goes to show you that they're not only targeting the direct companies who are doing this infringement, but they're also targeting the investment companies and other companies affiliated with them as contributing to this type of copyright infringement. As these cases progress and other companies develop, we may see suits launched in other areas that may implicate other types of law. So in the US, each state generally has different types of laws on unjust enrichment, deceptive trade practices, and various other types of claims that could be made. What we haven't seen very much yet is other types of law like likeness rights and rights to celebrity and so forth being enforced, but we anticipate seeing that a lot more in the US as famous people's voices or images may be used, or if AI is trained on voices of actors or other well-known voices. And this is all still really developing. Now, OpenAI and Meta haven't answered the complaint yet, so we don't know what types of defenses they'll be raising. However, this is a very new area of law, and it's developing very quickly, and we'll see what the courts in the U.S. Will do with it and how they'll rule. Thank you.
Well, that was giving another perspective on, especially on the scope of the lawsuits to address the companies, the financiers behind all of that. Very interesting perspective from someone actually practicing law and not just teaching at the university. Tia, your idea on that?
I think he summarized the lawsuit pretty well. As I said, the two newest ones are pretty similar to the previous one. Basically, the layout of the arguments is the same, the claims are the same, and I think they do summarize the gist of it all pretty well. And I think Adam did a great job explaining to us briefly what the whole thing is about.
That's cool. And now let us talk about what the whole thing is about. I'm gonna bring up this your slides.
Yeah,
are those the correct ones? Hopefully.
Yep. Since we're already over time, I'm gonna sprint through this. However, we do plan on having a sequel with an emphasis on European law. So for all those who want to know more, tune in. So the most important thing here is, where does the data go? Where does this famous training data actually end up? And the pretty straightforward answer is in the models. On the left side, you can see a paper published end of 2022. You see the two rows of pictures. The upper row are the generated pictures. The lower row is the training data inserted into the model that generated those pictures. Kind of looks familiar, maybe. I think with pictures, it's even clearer because anybody can see it.
It's more convincing, and yeah.
It's definitely more convincing. However, that aside, on the right-hand side, you can see a screenshot of GPT-3 that reproduced an entire first page of the Harry Potter novel. Again, if prompted correctly, you can very likely you can continue with basically having ChatGPT or GPT-3 or whichever model you take continue to write you a Harry Potter book. But again,
or a law book on on Austrian obligation law. That I mean,
I would rather go with Harry Potter though.
Yeah, okay, I get that.
In any event, the answer is pretty straightforward. The data does stay in the model. And this is also, to a certain extent, addressed in Anderson et al. Versus Stability AI. Well, this is actually an excerpt from the lawsuit, but they do explain it pretty well. I don't think that the term is maybe the best with the lossy copies. In any event, their key argument is that the essence of a picture, the essence of a book is taken. You can think of it something like DNA of the book, DNA of the picture is taken, and it remains as a lossy, as a restricted, reduced copy remains in the model. The fact that it's reduced doesn't do anything with the fact that it's still a copy. And that's why they probably still stuck with the lossy copy term.
I think it's just stored in a different, it's stored there, partially at least, and stored in a different way. But as long as it is retrievable, we might be, maybe the idea of having a slightly damaged solid state drive that can be restored partially would be a more appropriate term or explanation for that. But still, it's there, the data is there.
And now to show you two more interesting quotes on this topic, one from the lawsuit from Jane Doe versus GitHub. Plaintiffs do not identify specific subsections of each suggested license that correspond to each of these requirements, but the court finds that plaintiffs have sufficiently identified the contractual obligations allegedly breached. Very important. So you see that the developments in the US do tend to go in the direction that there is a copyright infringement going on, apart from what Matthew Sagg said about fair use. That there is a copyright infringement going on and that plaintiffs usually are successful at proving it. And for this reason, we have a paper by Mark K. Lemley and Brian Casey on fair learning, because their whole argument is that fair use doesn't really fit. So we need something else. We need fair learning because the models are only interested in learning the ideas and not in copying the materials. We can argue about that one. In any event, fair use is for a lot of people who want to still enable the models to learn out of the picture. And so now we can actually take a look at what the law says about the fair use. And it says the following. So it is only for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, meaning excluding for-profit activities. Very important. And a lot of these companies that develop these models maybe started or allegedly started as not-for-profit companies, but they are definitely not, they are definitely for-profit companies at this point. Second very important thing that makes it really difficult to pack these models under the fair use doctrine is point 4, effect of the use upon the potential market value for copyrighted work, which from the talk that we heard from Carla Ortiz is significant, and which also makes it very difficult to pack the models under the fair use doctrine. And now I prepared just a brief overview of the lawsuit. So we already heard the speech that Adam gave on the newest lawsuits. However, I briefly analyzed the key arguments from the previous lawsuit, as I said, pretty similar. Basically, they base their claims on the following. So how they know that the models were trained on the works? Well, because it makes sense. The models need large quantities of high quality data, which is basically only available in books. Secondly, the model could produce relatively accurate summaries of the plaintiff's works. These were also annexed to the lawsuit, and that does make the claim a lot more, well, graspable if you want it. Then the second thing that they dealt with is where did the companies actually get this data? And well, as some of you may know, OpenAI did say that they have books 1, books 2, and books 3. And they also said the size of these libraries. And basically, the lawyers in the lawsuit based their arguments that the only big enough libraries out there that could have served as books 1 and books 3 are actually the shadow libraries, so the Z libraries, Library Genesis Z hubs that basically have copyright infringement as a business model. And well, these actually fit perfectly with the sizes of the training databases that OpenAI publicly shared, unfortunately for them. So again, another pretty convincing argument. And as we also already heard from Adam, there are a lot of claims, in this case, 6 counts of claims. First, for direct copyright infringement, so copying copyright protected works to train the models. Second, vicarious copyright infringement, because outputs of the models occasionally do also violate copyright. Removal of copyright management informations, meaning watermarks, meaning the disclaimers in the books, so that isn't copied when they copy the works. Then unfair competition, which is paragraph 71 that you have there on the slide, and negligence, paragraph 75 that you see on the slide, which summarize pretty well the reasons why such models are not fair and why they should not be allowed to do what they have been doing until now, at least to the same extent and under the same conditions. And their final claim is, of course, unjust enrichment and claiming monetary damages for the authors, which is, again, a pretty straightforward, and I think anybody could agree, a pretty just thing to ask for.
Definitely. Really good.
And this brings us to the end of today's show. 10 minutes over time, I'm sorry.
It was like unexpected, but still we heard so many original voices from mainly the US. But whatever they said can be easily translated into European legal terms, or speaking of Carla Ortiz, her concerns are the concerns of also of all European the whole creative field, from writers to artists of any kind, for movies, pictures, drawings, etc., etc. Yeah, it was challenging. It is challenging, but also very rewarding. Thank you, Thea, for this episode. I hope we're gonna meet soon on the topic of privacy, and then come back to this very this daring topic of copyright and AI in another episode later in August, I guess.
Definitely, very broad topic, deserves probably a sequel. We didn't plan on the Senate hearing actually happening the day before, and we had to include it. So, you know, take what you can get, right?
Cool. See you, and see you next time.
See you.
August 9th. Ciao.